Our discussions on investments in general, and in particular, investments into private unlisted companies by private equity or venture capital funds, we have a general idea of how control and power and the day to day management works in a company. It's now time to move on to the A part of our M&A and PE course, which is acquisitions. Now, let's be clear on what kind of a transaction we're looking at, right? And in this case, we're looking at the difference between an investment and an acquisition. In a regular company without any investment, you'll have the promoter typically holding 100% of the shares. However, once an investor comes in, let's say at 26%, the promoter's shareholding gets diluted down to 74%. Now, this is a standard plain vanilla investment that we've already seen. However, in an acquisition, what will typically happen is that the promoter will sell out all its shares. In this case, it has 74%. It will sell out all its shares to the acquirer. And we're going to use these terms again. We're going to use the terms promoter and acquirer um, to signify who's coming in and who's going out. Now, remember, the promoter has considerable amounts of control in this company, and the acquirer is, well, acquiring that control. And the acquirer will become the new promoter of the company, right? So let's just take a look at the law that prevails in terms of transfer of shares, and that should be in the Companies Act. To begin with, we know that goods are shares. Shares are goods, and under the sale of goods, an intention and delivery of the goods are necessary. Registration is not necessary under the Sale of Goods Act. However, because shares also fall under the Companies Act, the registration of any transfer of shares is necessary not under the Sale of Goods Act but under the Companies Act. Now, Section 56 of the Companies Act provides for the applicable law with regard to transfer of shares. Now, let's take a look at what Section 56 says. It says that in order for a valid transfer to take place, um, the there needs to be an instrument of transfer, a share transfer form, which has to be executed by the transferor and the transferee, the person who's transferring, in this case, our promoter, and the transferee, our acquirer, which must contain their name, address, and occupation. This is to be accompanied by the share certificate of the company belonging to the promoter or the transferor, and this has to be delivered to the company within 60 days. Now, remember, the registration is with the company and not with the registrar of companies, right? So, effectively, the instrument of transfer is executed between the transferor, the seller, and the buyer, and deposited to the company. What does the company do? So, like we've mentioned before, the instrument of transfer need not be registered with the ROC nor with the sub-registrar of assurances, as was the case in immovable property. However, like we've mentioned, the instrument of transfer must be placed with the board of the company. Now, this must be signed by both parties, obviously, right? Now, what can the directors do? They may refuse to acknowledge the transfer of shares under Section 58. However, let's we do understand that because shares are goods, and it's essentially a sale of goods between two parties, one might take an argument that the board is not privy to this sale of goods, right? It has no role to play, or the company literally has no role to play in what is essentially the sale and purchase of goods, because they're not the buyer, they're not the seller. However, you've got considerable reasons as to why the company ought to be allowed to refuse to acknowledge the transfer of shares, particularly when if it's a minority shareholder who's selling out, right? Now, you wouldn't want a minority shareholder selling to a competitor. In that case, irrespective of whatever your articles say, here is a fail safe arrangement within the Companies Act where the company can protect itself from an unwanted transfer of shares. However, in this case, if we are looking at the promoter selling its shares and we're looking at a new promoter coming in, it is likely, most likely, that the company will not deny the transfer of shares, the board will not deny the transfer of shares. To let you guys know, the board may refuse the registration of the transfer under two grounds. A, that the board or the company does not approve of the buyer or the transferee. Like we mentioned earlier, we may not want to have our shares sold to a competitor. We may not want to have our shares sold to somebody who has been accused of moral turpitude or economic offenses. Or second, that the shares aren't fully paid up, that the company still has a lien on the shares. In which case, the company will ask the transferor or the seller to first pay up the call money on the shares, and then the transfer takes place. And of course, an appeal against the company's decision will lie with the NCLT. All right. Now, in practice, what do I need? As a buyer, what I need is my name to be there in the register of members. I need share certificates in my name. And I need a board resolution that specifically approves of the transfer of shares. Once I have all these three, I will have attained good title. Now, how do we get to this good title of these shares? The practice that is followed is pretty much similar to what we have seen in an acquisition. There's a preliminary contact and talks between the buyer and the seller. We also have a due diligence taking place between the buyer and the seller. We have them negotiate based on that due diligence, which results in a share purchase agreement. Now, within the share purchase agreement itself, there may be conditions precedent which will have to be satisfied, and then we move to closing, right? Closing are slightly different. Remember, we are looking at a transaction where the old promoter is going to be headed out and a new promoter is going to come in, which means that there is very little reason to have a shareholders agreement. Now, the new promoter will have control over the company depending upon its shareholding, but we do understand that it'll have the same amount of control as, let's say, the erstwhile promoter, which means that there is very little reason to have the articles of association changed in advance. So there doesn't need to be any agreement on the articles of association. Why? Because the new promoters will control the company, will be responsible for the company here on end, and will therefore be able to control the company as it sees fit. Now, at closing, obviously a board meeting is held. At this board meeting, the share transfer form is presented to the company. The company then takes on record the share transfer form that has been delivered, confirms that the share certificates are there, and that the transfer of shares, the sale of shares has actually taken place. At this point in time, the board must update the register of members. The share certificates must be endorsed over to the new acquirer, the new promoter, and all of this must be logged in the board minutes. Now, immediately after this closing agreement, this closing stage, there will most likely be a, a shareholders meeting, right? In the new shareholder in this shareholders meeting, where the new acquirer or the new promoter is coming, it is not uncommon to see the board being replaced, right? The board being replaced, or if there are any changes that the new acquirer or the new promoter wants to put in place, they do so immediately, right? But there are a few things to take care of after closing. Now, we'll take a bit of time on this. First is there might be indemnities that the erstwhile promoters may want to may give the acquirers. Now, remember, when we are doing a diligence, there might be a number of risks that are uncovered. Now, what the acquirer will want to do is to have these risks mitigated as far as possible, which means that there will be a lot more emphasis on conditions precedent, right? What the acquirer does not want to do is to be stuck with a company that has a number of problems associated with it. Problems that have been created while the erstwhile promoters were in control, right? However, if there are some risks, for example, there could be risks on, there could be risks on with regard to litigation, in which case the acquirer may insist that the erstwhile promoter indemnify the acquirers. It is not uncommon to see the acquirers retain some amounts of money as part of the share consideration or the share price to be paid. It is not uncommon for the acquirers to retain some of that share consideration until the expiry of the litigation event or the threat, right? Now, what a number of acquirers and promoters do is that they set up an escrow account, right? So let's see how this works. So the acquirer will pay some of the share consideration money to the promoter, but it will also set aside some the rest of the share consideration to an escrow agent, which is usually a bank. Now, both the acquirer and the promoter will agree that upon the expiry of a particular amount of time or upon the happening of a particular event, that escrow money might be returned to the acquirer or might be sent to the promoter. For example, let's say there is a threat of some litigation, right? That the company has done something which is a cause of action, but no legal proceedings have commenced yet. Now, we know for a fact that legal proceedings against a cause of action must commence within 3 years or 7 years or 11 years or 12 years, whatever be the limitation period. Now, what the acquirer can do is the acquirer can say, all right, we've got a cause of action here, but what we will do is we will set aside some amount of money in an escrow account to see if there is legal proceedings arising out of this cause of action. If after 3 years of this cause of action, if there are no litigations against us, then this money will be released to the erstwhile promoters. If there is a legal proceeding that is commenced against us, then this money will come back to us, right? So there's you a lot of acquirers require and insist that some risks be indemnified by the erstwhile promoters. Second, in order for a smooth transition to take place, the erstwhile promoters may enter into what's known as a management contract or a management services contract. Now, what this services contract does is it requires the promoters to continue working within the company or as an advisory role to the acquirers while transitioning from an old management to a new management. This ensures that the people, the key managerial personnel, the people who are working in the company, their loyalties switch from the old management to the new management. There may be idiosyncrasies, quirks, and routine company affairs which are unique to the company. Now, the new management will take some time to learn about these practices at the company, which means that there is a transition phase. To ensure that the promoters actually do this transition properly, we will enter them into a management services agreement or a management contract, right? For which they are paid, right? For which and they are paid for their services. The third and final aspect that we should be looking at is what happens to the promoters after they after they exit the company. What I would not want is for our erstwhile promoters to reach out to the supply chain networks or the customers that the company has and say that, look, we've sold our old company, we are setting up a new company that does exactly the same thing that the old company did. We want you to continue buying from us or selling to us, right? So what that does is it creates more competition in the market, right? Now, as an acquirer, I can insist and I can require the promoters not to do so by engaging them or entering them into a non-compete and confidentiality agreement. Again, we know what non-compete and confidentiality agreements do. They basically tell the promoter, in this case, they will tell the erstwhile promoter, that you cannot enter into a competing business, you cannot commence a competing business, and that whatever information you have about the company that you've received as part of the company, you will not disclose that to anybody else, right? So we are basically protecting the acquirer against any risks that the promoters may have created. We are ensuring a smooth transition from the erstwhile promoters and the acquirer, and we are entering into a non-compete and confidentiality agreement to ensure that the erstwhile promoters do not disclose anything about the company and they don't enter into a competing business, right? So this was how an acquisition takes place for a for an unlisted private company, right? It becomes a whole lot more complicated when it's a listed company, right? So of course, we'll do a separate video on this, but effectively for a listed company, there are no changes as such in terms of minor trades, but I must report to stock exchanges and SEBI in cases of any transfer more than 2% of the company, right? And if I am transferring more than 25%, or 5% in certain cases, we'll come to that when we come to it, we will have triggered the takeover code, also known as the SEBI Substantial Acquisition of Shares and Takeovers Regulations 2011, right? So that's it about private company acquisitions. It's been fairly simple. We go over the same sort of pattern of preliminary talks and negotiation, due diligence, formal negotiation that leads to a share purchase agreement and not a share subscription agreement. There is hardly any use for a shareholders agreement, primarily because, well, the new shareholders or the new promoters are going to be in control of the company. And of course, post closing, we'll have a number of fail safe mechanisms and agreements that we ought to be entering into to protect the company as well as the acquirer.